Advice to Simon Ikpa: red flags in legal representation. What his case teaches us: the red flags surrounding Gento de Yahoo's disappearance, his girlfriend, and the Nigerian military's claim. Hi everyone, welcome back to the channel. Today we are diving into an important topic: how to know if your lawyer is truly working for you, whether you are dealing with a civil case, a criminal defense, or even a simple contract dispute. Your lawyer is supposed to be your strongest ally, an advocate, and a backer. But sometimes, people start to wonder, is my lawyer really on my side? In this video, we will cover 7 clear signs to look for and what you can do if you're concerned. Watch this video right to the end so you don't miss any of the topics I introduced at the start. Understanding lawyer and client relationship. First thing first, remember the basics. Duty of loyalty. By law, a lawyer must act in the client's best interest. The duty of loyalty is a fundamental legal and ethical obligation that requires a lawyer to always act in the best interests of their client. This means a lawyer must put the client's needs ahead of their own personal interest or the interest of others. For example, a lawyer cannot represent another client or take on work that creates a conflict of interest with their existing client. The lawyer must remain faithful, avoid divided loyalties, and provide representation that is free from bias or self-gain. Ultimately, this duty ensures trust, fairness, and integrity in the attorney-client relationship. 2. Duty of confidentiality. What you share should stay with you and your lawyer. Confidentiality is one of the cornerstones of the attorney and client relationship. It means that anything you share with your lawyer, whether spoken, written, or otherwise communicated, must remain private and protected. A lawyer cannot disclose your information to others without your permission, except in very limited circumstances required by law, such as preventing a serious crime. This duty encourages clients to be open and honest with their lawyers, knowing that their secret strategies and personal details will not be exposed. In turn, this trust allows the lawyer to give the best possible advice and representation. Now, here is the thing. Listen, a few days ago, I watched a video where a content creator claimed that Simon's lawyer went to the correctional center to ask him about his relationship with Gento de Yahoo. The creator went on and on, sharing details of what Simon and his lawyer apparently discussed. He even admitted that what he was saying came straight from that private conversation, something that should have stayed confidential. Now tell me, if what you discussed with your lawyer is already all over social media, then where is the confidentiality? Simon, my brother, let's be real, we are not fools. From the very first day, you should have known that no matter how good the white man seems, his own interests will always come first. The man you trusted had already failed you from the start. Think back, you were first called for questioning and they took your documents. Later, they called you again, but this time they detained you, refused you bail, and locked you up in a center meant for criminals. That alone should have told you these people are not for you. And now, the same people who locked you up are the one giving you both a lawyer and a prosecutor. How can you win like this? You can't. They sentenced you to 6 years in their district court, and don't think it was by mistake. They knew exactly what they were doing. You appealed, but from what I heard in another video, even in your private conversation, it came out that you and your lawyer met with the prosecutor, because subsequently the prosecutor himself said he was tired of the case and advised you to take the 6-year sentence. He even hinted that they might open a new case against you in the appeal court. That means he knows something you don't. Simon, I also heard you say, let's look at this from a human standpoint. But my brother, there is no human standpoint in a legal battle. Court is about strategy, nothing more. Whether the accuser or the accused goes to jail is not your concern. You just have to focus on winning. But listen, they are going to use the Gentle the Yahoo incident to trap you again, and it won't be easy. You are not there. You are on your own. Nobody is coming for you. Not even the government in exile you instituted, unless God himself steps in. And honestly, justice is not on your side. The system has changed now. Even someone you have never met can accuse you of something, and then we build a case out of thin air with circumstantial evidence. My advice, brother, take the 6 years, serve it and come out free. If they pardon you, it will come with so many conditions that you won't be able to live in peace. It's better to face the time and regain your freedom than keep hoping for fairness in a system that isn't designed to give you justice. Another one is duty of competence. A qualified lawyer required to give competent, diligent representation. Competence means that a lawyer must have the knowledge, skill, and preparation needed to handle a client's case properly. It's not enough to simply show up. A lawyer is required to study the case, understand the relevant laws, and apply diligence at every step. This duty ensures that the clients receive professional and capable representation. If a lawyer lacks the necessary experience in a particular area, they must either learn it quickly, seek help from another qualified lawyer, or decline the case. In essence, competence protects the clients from careless mistakes and guarantees that their case is given the serious attention it deserves. Knowing these responsibilities makes it easier to see when things are off. And let's be honest, Simon's lawyer has not shown competence. From the way things look, he is either working with the prosecutor or serving the very government that appointed him. If you step back and look at the case holistically, it's clear he is not truly defending Simon's interest. Simon doesn't need a lawyer tied to the system. He needs someone from a neutral ground. I also heard that a lawyer from the southeast flew to Finland a few days ago to meet with Simon. But tell me, how can you trust such a lawyer? Where was he when Simon was being railroaded in the Pejathem District Court? Why is he only showing up now? If he couldn't stand up for Simon when it mattered most, what makes anyone believe he will do so now? Now let's look at the 7 signs your lawyer might not be fully on your side. Poor communication, that is number one. Poor communication is a red flag in any lawyer-client relationship. It shows up when lawyers really return calls or emails, or even they give vague answers to direct questions. If you have been following Simon's case, you will notice this pattern. Each time he speaks with his lawyer, instead of explaining things clearly or guiding him, the lawyer turns it into an interrogation, asking questions as if Simon were on trial. That is a clear example of poor communication. 2. Unexplained delays. Deadlines are missed or documents take for longer than reasonable without a clear reason. That is 2. Let's go to 3. We are taking those one that is tied to Simon's case. 3 is pressure to settle quickly. They push for a settlement that seems too fast or too low without explaining pros and cons. Now listen to this. After Simon was handed 6 years sentences, his lawyer asked him if he would take 6 years or appeal the case. That kind of question is reckless. It puts Simon under unnecessary pressure. At a critical moment, a competent lawyer should never dump such a heavy decision on the client without guidance. His job is to analyze the case, explain the risks and benefits of each option, and fight for the part that serves his clients best. Anything less is incompetence and a betrayal of duty. That is exactly what Simon is going through there. I don't think he have realized that because of the situation he finds himself. It's not easy to think critically when you are in a such place they put him. So let's move on. For conflict of interest, they have ties to the other party financial business or personal that they didn't disclose. 5, lack of transparency in fees. You get surprise bill or can get a clear explanation of costs. We don't know how Simon is paying him, so let's move on. 6 is ignoring calls. They steer the case in a direction you never agreed to or dismiss your concern. I saw this exact thing playing out in Simon's case. 7, breach of confidentiality. Any sign that your private information has been shared without permission is a serious red flag, which is also happening in Simon's case. We don't supposed to hear any form of conversation from the lawyer regarding Simon's relationship with Gentle. It's supposed to be private because bringing in Gentle into the case make the case a very high profile case. Now, what to do if you suspect a problem? Document everything, keep emails, text and note of every conversation. Request a meeting, calmly express your concern and ask for explanation. Seek a second opinion. Another lawyer can review your case and give independent feedback. Consider changing lawyer if the trust you have for the one is gone. Most courts allows you to switch counsels mid-case. Contact a bar association in the serious cases. You can file a complaint with your local or national bar. Remember, trust is the cornerstone of a lawyer-client relationship. If you feel uneasy, don't ignore your instincts. Ask questions and protect your own interests. The red flags surrounding Gentle's the Yahoo's disappearance, his girlfriend, and the Nigerian military's claim. Let's watch this video and I'll be back.
If you watch our video we released yesterday, we clearly explain every single thing. You can't be saying that true. Yes. From what the year, from what the Nigerian government they supply the prosecuting lawyer, say Gentle they in their custody and him they cooperate with investigations. And so far so good, they don't furnish the prosecuting lawyer with info. Now, the video with this man released before he was arrested, in talk say Ngozi Rabueze never send one kobo to him. He never sent one kobo to him, and she did do fundraising every single day and every single time. But yet, still, she never give him any form of give the guy and the soldiers any form of assistance, which simply means that Simon being the one way or the other run that levels. I don't want to use my mouth talk am. If you know, you know. So wetin be the cocoa now, and wetin be the bone of contention now? Well, as they speak, this girl they talk say she know where Gentle dey, and this Gentle they willing and ready to make a full statement and make a full video coverage. Okay, wetin they hold the whole process. Well, she's saying that Gentle now no trust anybody. If you feel like say if you make a video now and post it on online, people where they within, people where they very close to him go fit track him and tell the Nigerian army where he dey and his location. So wetin be the conditions now? Well, Gentle, based on wetin she dey talk allegedly, Gentle is claiming that he no trust anybody within the government of the USB, and he no wan come outside come make a video. That if ever he wants to speak from now henceforth, he go dey speak from his girlfriend, and his girlfriend will come outside, they give full disclosure and full revelation. Now problem don't start fully. Now problem dey. Why? Okay, take for instance, if Gentle, if say this man dey alive, can't they speak through his girlfriend, it go become a big problem for everybody within the USB system and the USB government, because you no go know who and who they talk. You no go know where this information they come from, if it's faked, if it's forged, or if now wetin she dey sit down can manipulate by herself. But that's not the case. Now let's go to the interesting part of this whole conversation and the interesting part of this full coverage. Wetin dey happen for Finland regarding the case of Simon? Well, that video wey Gentle make don go super viral. For that video, in the talk say Simon be the supporter one way or the other. That one a problem. The prosecuting lawyer now don't get all the evidence we need. He don't get all the documents we need to fit prosecute Simon fully. But
welcome back. First question is, if Gentle dey, so let's look at hearsay and evidence rule. Court usually requires verifiable evidence, not just second-hand statements. If the lawyer who is in military custody and provides information through the prosecuting lawyer in Finland, will the court accept that information without any evidence, providing he is actually in military custody? Let's look at how courts that strive to remain unbiased generally handle this kind of case. Only passing along with someone allegedly told. If the lawyer is only passing along what someone allegedly told them, that is normally treated as hearsay unless it fits a specific exception. Proof of custody. If one key claim is that Gentle is in military custody, the party presenting the information will normally need some proof of that fact. For example, an official record or credible witness testimony. Without it, the court is unlikely to rely on the claim. Let's look at jurisdiction matters. Exact procedure depends on the country and the type of case. As I said, Finland, for instance, follows strict evidentiary rules. Statements without supporting evidence are rarely conclusive. That means evidence must be strong-willed. So in most systems, information are allegedly coming from someone whose custody status isn't even proven, carrying little or no legal weight, unless it's independently corroborated. Now, let's look at the second question. If Gentle is actually in hiding and his girlfriend publicly claims that he is alive but will only communicate through her, will a court accept any information she provides on his behalf? Let's look at how courts usually treat this kind of statement. Hearsay again. The girlfriend will essentially be repeating what Gentle told her. In most legal systems, that is known as classic hearsay. it is a statement made outside the court offered as truth. Courts rarely admit hearsay as evidence unless it falls under a particular exception. For example, certain emergency statements or written affidavits with the person are valuable for cross-examination. Need for direct testimony. If Jonto himself is the source of the facts, the court will generally require his own sworn statement or in-person testimony, not someone else speaking for him. Credibility and verification. If the girlfriend provides a signed statement or affidavit, the court typically wants to confirm that the communication really comes from Jonto. For example, through notarized document or verified electronic communication. Without independent verification, the information carries very little legal weight. The bottom line, unless Jonto himself appears, provides an affidavit, or the statement falls under a recognized hearsay exception, most courts will not treat the girlfriend's words as reliable evidence on his behalf. If you found this video helpful, give it a thumbs up, subscribe and share it until it gets to Simon and with anyone who might need this advice. Thanks for watching. I will see you in the next video.